22nd, 2025, Board of Douglas County Commissioners 5:30 business meeting. Paper copies of the agenda are available for those here in person, and the full packet is available on our website. Reviewing our agenda, first we'll consider our consent agenda. There are 3 items on that agenda. After our consent agenda, we will have general public comment. We welcome general public comment for addressing issues not on today's agenda, but otherwise related to county business. Given our limited time and the need to have an orderly and efficient meeting, we apply certain rules regarding public comments. We'll do our best to enforce these rules consistently and without regard to the point of view expressed by the speaker. Here are the rules. 1, each speaker will be limited to a total of 3 minutes of speaking time. However, we will accept public comment of any length in writing. 2, individual speakers may not donate unused time to other speakers. 3, all comments must address topics within the jurisdiction of the County Commission. And 4, we reserve the right to mute and remove any speaker whose comments are threatening, aggressively hostile, or belligerent. Campaigning for public office during the public comment period is not allowed. We ask that you give your full name and address if you like for our meeting minutes and address your comments to the commission. Please also know that comments received by the County Commission during our meetings do not necessarily represent the views of Douglas County government, and we value the input. We don't usually respond to general public comments on the spot, but if you leave your contact information with county staff, we will try and get your specific questions answered. After that, we'll move to our regular agenda. There are 2 items on our regular agenda this evening. One is a request for a temporary business use permit to allow utility scale solar related to geotechnical site investigation, soil sampling, and underground surveying. And the other will be an executive session. For each of those actions items, we'll hear from staff or the applicant, followed by questions from commission, and then open the item up for public comment relative to that item. Once public comment is closed, we'll bring the item back to the commission for further discussion and a vote. Lastly, a recording of this meeting will be available on the county's YouTube page and website. At the top of today's meeting, we have a proclamation for World Polio Day, and Commissioner Willie has agreed to read that proclamation.
Yes. So we have a proclamation for World Polio Day in Douglas County, October 24th, 2025. Whereas Rotary International, founded on February 23rd, 1905 in Chicago, Illinois, USA, is the world's first and one of the largest nonprofit service organizations. And whereas Rotary is a global network consisting of over 1.4 million members in more than 46,000 clubs in 221 countries and geographical areas who unite as neighbors, friends, leaders, and problem solvers to take action in creating lasting change in communities across the globe. And whereas to date, Rotary has contributed more than 2.6 billion in countless volunteer hours to protecting nearly 3 billion children in 122 countries. And whereas Rotary is working to raise an additional 50 million per year, which should be leveraged for a maximum impact by an additional 100 million annually from the Bill and Melinda Gates Foundation. And whereas there are 122 members of the Rotary Club, 85 members of the Jayhawk Breakfast Rotary Club, and 42 members of the Lawrence Central Rotary Club, who sponsors service projects to address such critical issues as poverty, disease, hunger, literacy, and the environment in our local community and abroad. And whereas Lawrence Rotarians have committed their time, talent, and treasure to continue support of Polio Plus until polio is fully eradicated from the earth. Now, therefore, the Board of County Commissioners of Douglas County, Kansas, do hereby proclaim October 24th, 2025 as World Polio Day in Douglas County and encourage all citizens to participate in this observation, adopted this 22nd day of October, 2025.
Jennifer, would you like to say a few words?
Hi, I'm Jennifer Berquist here from Lawrence, Kansas, and a member of the Lawrence Rotary Club. And I'm also representing the Jayhawk Breakfast Rotary Club as well as Lawrence Central. And I want to thank you for signing the proclamation today. And I also want to read a very short email I got from Rotary International last night that's very fitting. How successful has the effort been to eradicate polio? Because of Rotary's support, nearly 3 billion children have been immunized against polio and are protected for life against this crippling disease. Rotary and our partners reduced the number of wild polio cases from 350,000 in 1988 to 25 in 2024. 20 million cases of paralysis have been averted through this global effort. The wild polio virus is now endemic in just 2 countries, and we won't stop until our efforts until we're able to give children a polio-free world. Thank you very much.
Thank you, Jennifer. We have your signed proclamation here. Would you like that? Okay, we'll move on to our consent agenda. Commissioners, is there any item on the consent agenda you'd like to have removed for further discussion? Seeing none, anyone here at the courthouse who'd like to have a consent agenda item removed for further discussion? Online, Sarah? All right, Commissioners, I'd welcome a motion on the consent agenda.
Commissioner Reed, move to approve 2.1 through 2.3.
Second.
Moved and seconded. Any further discussion? All those in favor signify by saying aye.
Aye.
Opposed? Passes 5-0. We'll move on to general public comment. If you'd like to provide general public comment, now would be the time. Step forward to the podium.
Hello. My name is Adriana. My zip code is 66049. Good evening, commissioners. So far, it has been 532 days since the Douglas County Commission pledged to establish a tenant right to counsel. That would not only save money, but more importantly, save households in dire need. That's 532 days. That's over a year and a half that families in our community have been waiting for a critical lifeline that this body has already heard, reviewed, seen facts and figures presented, repeatedly asked for those facts and figures again, and this body agreed to it as a key component of a Place to Everyone plan. In that time, the crisis of eviction has not paused. It has continued unabated behind the closed doors of courtrooms where nobody can see and nobody can care. Lawrence Tenants has been tracking that crisis these past 532 days and counting. And we feel we have a moral obligation to share with you what 532 days of active inaction looks like in terms that are easy to grasp. To make this invisible crisis visible, we have undertaken the task of pulling data from each of the court dockets for the past 8 months to share with this commission, wherein this indispensable matter is disregarded by fruitless discussion, repeated requests for data that we have already presented numerous times, and is ever on the back burner instead of being concretely worked towards. Since first we came to petition this commission, Douglas County has seen more than 800 eviction filings. So between 800 and 910 by our best verifiable estimates from court records. Each filing is not a spreadsheet, but a human life. It's a single mother trying to keep her child's bed warm, a couple undone by layoffs, a survivor of domestic violence for whom stable housing is a fragile barrier between safety and danger, and the harm lands heaviest on our Black and Brown and LGBTQ plus neighbors who are disproportionately targeted and left with no counsel to push back. Without a tenant right to counsel, landlords are provided a get out of justice free card for discrimination. Even within our dockets, we can trace 168 households by case number, and the true total climbs well past that, over 330 since the end of Q3. Each of these numbers is a household in crisis whose loss of basic needs, housing foremost among them, could have been mitigated with counsel, compassion, and a fair hearing. I will now exhaustively list the case numbers we have compiled.
Cassandra Barrett, 66044. I'll pick up where Adriana left off and read these case numbers for you. Douglas County Case 2025 LM 00304, 00403, 00165, 00441, 00448, 00474, 00440, 00507, 00526, 00519, 00523, 00510, 00583, 00506, 00516, 00484, 00514, 00575, 576, 574, 577, 545, 586, 544, 640, 623, 615, 628, 649, 621, 647, 642, 813, 814, 847, 828, 861, 881, 882, 920, 910, 901, 900, 1016, 1031, 1001, 1007, 1008, 1021, 1248, 1247, 1264, 1255, 1296, 1300, 1299, 1302, 1276, 1277, 1279, 1301, 1290, 1284, 1278, 1273, 1275, 1403, 1364, 1373, 1372, 1374, 1386, 1325, 1389, 1387, 1546, 1548, 1547, 1544, 1542, 1565, 1534, 1535, 1543, 1541, 1531, 1530, 1538.
Done.
Thank you.
Hello, Cornelius Baker. My zip code is 66044, and I will be continuing the eviction readings from Cass. One 539, 1518, 1519, 1521, 1523, 1522, 2059, 2074, 2085, 2091, 2096, 2097, 2109, 2116, 2125, 2138, 2311, 2311, 2312, 2272, 2280, 2203, 2309, 2310, 2313, 2169, 2308, 2270, 2273. If that felt tedious to listen to, imagine how much worse it feels to be in eviction court and to be in fear of losing your housing. And multiply that number by 2 to get to the number of people who have evictions filed against them this year.
Katie Kraus, 66044. Now we've talked about cost. Let's talk about the real costs. See, we agree that fiscal responsibility is important. That's a no-brainer. But we must ask, what is the greater cost? No, seriously, what is the greater cost? As we cited before, we will cite it again. Tenant right to counsel programs are proven cost-effective investments in the Proven cost-effective investments in the communities where they have already been enacted will actually save money by preventing homelessness, which in turn reduces the immense public expenditure, vastly so in counties with very large homeless populations, like ours. It saves us money on emergency shelters, social services, and healthcare, as well as however many other homeless resources the individual community has. And ours has lots, in no small part due to the county commissioner's decisions. The upfront cost of an attorney barely makes a dent in comparison to the long-term financial commitments resulting from yet another one of our neighbors becoming homeless yet again. And for the county to shelter, feed, clothe, police, medically treat, and just generally take care of them. Ladies and gentlemen, we have allocated millions of dollars for capital projects that do not guarantee a return on investment, while we have shared the return on investment that Tenant Right to Counsel will provide. Surely we can allocate funds to protect our most vulnerable residents from traumatic, needless upheaval. And surely we would be wise to do so, knowing the return on investment that comes along with it is real money that really means getting to do even more county things. You see, time is not a neutral force. It ticks and it talks and it never stops. And with every single day that ticks and talks away, more and more families are served with eviction papers that might not even be legal. More households are uprooted, and our community is weakened by such making weak and breaking links. People, we are here tonight to remind you all of your commitment and to ask you for a concrete timeline. When will the County Commission take definitive action to fund and implement the Tenant Right to Counsel? 532 days of delay is 532 days too many, especially when promises come to zero fruition, when concrete progress is sorely overdue for the people to see. Our community can't afford to wait any longer. So we demand that you, esteemed commissioners, and all of those around us who are here tonight, that the County Commission places Tenant Right to Counsel into County Code, thus ensuring that every tenant facing eviction is eligible for a fair hearing.
It's time.
With respect and sheer reverence, Katie Krause.
Hi, Commissioners. My name is Carol Schmidt, and I'm here to, because of the public hearing for the temporary business unit permit
Carol?
for,
That's an agenda item for
Oh.
us, and we'll have public comment on that agenda item when it comes up.
okay.
Can you
so
save your public comments till then?
Okay, so that's after what?
Yep, it's coming up next.
Okay.
Yeah.
Sorry.
Thanks. Any other public comment? Anyone online, Sarah? Okay. Commissioners will close public comment and move on to our regular agenda. The first one is a zoning and codes item, ZTBU 2025-002, ZTBU 2025-0003, ZTBU 2025-004, ZTBU 2025-005, and ZTBU 2025-006 to allow utility scale solar related geotechnical site investigation, soil sampling, and underground surveying. Carl, I hope that gave you enough time to come up front and get your PowerPoint loaded. Welcome.
Thank you and good evening, Commissioners. My name is Carl Bauer and I'm a planner with the Douglas County Zoning and Codes Department. The applications before you tonight are for temporary business uses. So I want to just quickly explain what that is. So per the zoning code, there's a section that defines what is a temporary business use. And within that section, it says that equipment used for environmental data collection is considered a temporary business use. And all temporary business uses require a temporary business use permit, which is what you'll be voting on this evening. This is a similar process to what an unrelated project went through in 2023. There were some similar applications that came forward to do similar testing. on a different side of the county for an unrelated project. So temporary business uses are often compared with conditional use permits. Temporary business uses are processed by the Zoning and Codes Office, not the Planning Department, and they're considered by you. They only come before you. They're not considered by the Planning Commission. And because of that, they have a more expedited timeline for review. It's also intended for uses that are generally pretty temporary in nature. The applications before you tonight are from Evergy Kansas Central, Inc., and they are to allow environmental testing related to a commercial utility solar energy conversion system project known as the Kansas Sky Energy Center, a CUP for which was approved in April of 2024. The applicant is seeking to do some geotechnical testing on the subject properties that aid in the design of the project. The applicant is here tonight and they can explain in more detail what's involved in those tests. The proposed testing activity will include drilling boreholes, digging test pits, double ring infiltration testing, pile load testing, thermal resistivity testing, soil sampling, and surveying for drain tile points and gas line points. There are 13 subject properties involved and they are spread across 5 sections in Grant Township, and these TBU permits are being considered on a per section basis. This is a list of the properties involved, as well as the sections in which they're located, their acreage, who the property owner is, which activities are going to be taking place, as well as which permit number they're associated with. And then this is a map produced by the applicant showing where each of these testing activities will be taking place. And as I mentioned, this is being processed on a per section basis. So you see the 5 sections involved highlighted on the map here. All of the properties associated with the testing are zoned Ag 1, except for one 1-acre property that is zoned Ag 2. The area, for the most part, is also within the airspace overlay district. In addition to the agricultural zoning, there's a CUP for the subject properties for a commercial utility scale solar energy conversion system. Several of the properties are also within Tier 3 of Lawrence's urban growth area, and there is one subject property that's adjacent to city limits. That's Riverfront Park. Most of the surrounding properties are developed with single-family residences or farms or some combination of the two. Surrounding land uses include some commercial and industrial uses, as well as the Lawrence Municipal Airport. Just some highlights of the review of these applications. The applicant indicated that testing for this project is temporary. There's no permanent infrastructure or equipment being installed solely from this testing activity. So staff does not anticipate any permanent impact to any wetlands, floodplain, or prime soils on the properties. And after the testing, the ag uses of the property could continue. The testing activity may generate some noise, so a recommended condition of approval is that the testing activity only be done during normal working hours. That's intended to mitigate that impact. There's also a recommended condition that the applicant notify the Zoning and Codes Office 24 hours before they begin the testing, just so that we know what's going on. And if we get any calls, we're able to tell the caller what's going on. We're also not, staff is also not expecting traffic to exceed existing levels or intensity. Per the applicant, the testing is temporary in nature and short in duration. There's a maximum crew size of 13 employees, and the equipment includes 1 drilling rig, 1 flatbed carrier truck, 1 backhoe and excavator, 1 pile driving hammer, 2 Ford F-250 trucks, and 5 F-150 trucks. With a temporary business use, there's a requirement that staff sends out notice to property owners within a half mile, and that must be done at least 10 days in advance of the public hearing. So staff mailed a total of 91 letters to property owners, both in Douglas and in Jefferson County. Staff also sent out a solicitation for comment. We heard back from Grant Township and from Southern Star Pipelines. We also received 1 public comment that just came in last night. It was from one of the property owners of the subject properties, and he was generally in favor of granting the request. So with that, staff is recommending approval with the conditions as listed here. Staff is recommending approval for a 1-year period as there is litigation that's going on. This would give the applicant some flexibility in case there are some delays. All of the testing activity must be done within a 6-week window. With that, I'm available for questions. The applicant has their own presentation as well.
Thank you. Commissioners, do you have questions for Carl? Okay, let's move to the applicant's presentation. Matt, can you hit the button? There you go.
That's a new button, isn't it? Thank you. My name is Matt Goff. I'm with Barbara Emerson Law Firm. My client is the Free State Solar Project LLC, doing business as Kansas Sky Energy Center. Evergy, however, is the applicant for this, and I'm joined today by Andy Koleski with DEPCOM, who's a consultant with Evergy, so I'm going to turn it over to him. Thank you.
Thank you, Matt. My name's Andy Koleski. I work with DEPCOM Power, speaking on behalf of the Kansas Sky Energy Center, and we'll walk you through briefly the presentation that we've put together for today that will describe and share some photos showing the nature of the geotechnical testing that we are seeking approval for with this TBU permit. And before I continue, just quick introduction for my colleague here, Ryan Shrimplin, also with DEPCOM Power. Please feel free to interrupt me with any questions, comments. All right. So a quick summary, in addition to what Carl already shared. This list shows the quantities and locations of the testing that we are seeking, which I'll get into in a little bit more detail in a moment. Just high level soil, there will be soil borings at 13 locations, test pits at 17 locations. There are a total of 26 piles or posts that will be driven in the ground and tested and then removed. 9 locations where infiltration testing will be performed. And then thermal resistivity testing, 6 samples will be collected. And then I'm going to jump to the bottom. There's also 12 locations where soil sampling will be tested and performed. And then the drain tile and gas line surveys will be tested at 39 and 6 locations respectively. Before I get into the next slide, any questions or comments that I can answer?
What is drain tile testing?
Great question. So I think I left out a key word there, surveying. We would be performing a survey, a non-invasive survey, attempting to validate the location and depth of portions of the project site that have drain tile existing underneath in some of the farmland. And just for a little more background context, we have from Evergy received a map of where these drain tile locations are believed to exist. And again, the nature of our surveying here is to simply perform validation of those locations with the ultimate goal of avoiding them as much as possible during construction. And same comment would apply with the gas line surveys. Mm-hmm. All right, so I will start with speaking to soil borings, and this would also apply to soil sampling as soil samples in one of the tests called the thermal resistivity testing that I mentioned would be actually taken from some material removed from site. So the soil borings would be performed by a drill rig and one or two at most support trucks. Again, similar in size to an F-150 or F-250 at the largest. The drill rig will perform either 20-foot depth or 50-foot depths in fewer sections of a 4 1/4 inch diameter bore. These tests would take 40 minutes to an hour and a half at most. Once the samples are observed and taken, the material will be backfilled into the hole that they were taken from and tamped down with another tool called a sampling spoon or a hammer that would be on the drill rig itself. I forgot to mention one important thing for this test and for all other tests described here. Any existing vegetation or topsoil would be separated and isolated from native material beneath the topsoil, and then native material will be replaced. Topsoil would be replaced back on top of that. Yeah, again, 13 locations for the soil borings that would be performed, and that coincides with some of the soil samples that would be taken as well. So there's a couple instances where the contractor would be able to collect a sample because they're doing a soil boring in a similar location. There's a few instances where, hey, we need to collect a sample and they're gonna go collect that specifically. But in most cases, there's this crossover here. Any questions or comments before I continue?
You mentioned observation on site. So do you complete all of your observation and analysis on site at that moment?
Some samples are removed for further lab testing, but the majority of the material will be returned back, to where it came, whether it's a test pit or a soil bore in this case. And, that for all of these, the test locations are returned back to existing condition as much as possible. Again, with topsoil separated and then replaced. So I know there was a question that was asked about how many kind of trips or passes through a certain area would occur. At most, that would be about 3, for instances where perhaps you need to do a pile test and a soil bore. In most cases, 1 or 2 passes through any given area would occur, spanning at most a handful of days, and then there would be no returning to that test area. A couple of the tests, which I'll get into in a moment, like the pile testing specifically, the piles need to rest for 72 hours before they're tested.
Do they rest on site?
They would, yes. Okay. And then they'll be removed permanently and disposed of offsite.
Why are they disposed of offsite?
That's specifically for the metal posts that would be installed. Here, I will actually jump ahead to that one real quick. So just a steel beam essentially will be driven into the ground and rest for 72 hours, after which an excavator with some test equipment will perform load testing on that post. And then once the data is received, the post is extracted from the ground. The hole or any void that's remaining would be backfilled with the native material and then topsoil replaced on top. And then the posts would be removed from the site and disposed of at a metal recycling facility.
Oh, the post is, okay. I thought you meant that the dirt itself was actually
No.
disposed of offsite.
No.
Okay, thank you.
Do you use the existing field access points when you're coming and going from the fields?
That is correct. That's the intent. So for site access for all of these test locations, we have mapped out entrance locations corresponding as close as possible to where the eventual site entrances are planned for. And I guess to that effect as well, it is part of the design. They're most often coinciding with existing, agriculture entrance points.
But for the testing, you're using the existing field access points. You're not creating new field access points.
That is correct.
Thanks.
Yeah, no additional entrances are being constructed. Thank you. Any other questions on soil borings or soil samplings?
I have one a little random. Generally, how deep are our drain tiles located?
For the drain tile, the drain
the
tiles in
existing
question that
field.
we're going to be performing the survey for, 3 to 4 feet deep
Thanks.
is what we've been told. So, All right, I will continue and describe test pits. So again, we've got 17 locations planned for test pits. Just to kind of describe the nature of the testing here, again, with a pit being dug and then backfilled, topsoil will be stripped, placed on one side. Test pits will be approximately 10 feet deep and the width of an excavator bucket. So on the left photo there, you can kind of tell it's a relatively narrow hole, 10 feet deep. So they'll be open for at most 1 hour prior to being backfilled, and they'll be backfilled in 12-inch lifts and then compacted with the excavator bucket all the way up to the surface, and that's performed in that nature to prevent any settling that would occur. So it'll be compacted, brought back to the surface once the testing is completed, the observations made, and then topsoil will be replaced back exactly where it was before. And the, I guess one additional comment just to add, over the course of the testing, the contractor, the geotechnical contractor will be returning to the test pits just to perform a visual inspection 24 hours after they have been completed, simply to observe if there's any settling, and if there is, then they have a remediation procedure to bring the surface elevation back to the top and again replace the topsoil. Any comments or questions?
I had a question. This may not be the time to ask it, but I think it was mentioned that the testing will take about 6 weeks in total. I presume in there you're not counting for rain, or because I think rain would give you a problem, wouldn't it?
Absolutely. That's a great question. And you're correct. 6 weeks was what was submitted on the original applications, and that was a conservative estimate. Assuming there are no weather impacts, the testing can be completed in 15 days. So essentially in half that time, but if there's rain or other weather, that would potentially extend that a little bit. So that's where the 6 weeks came from.
Is there a preferred time of year for that 6 weeks to occur, particular season?
No, I would say no. There's, I think it's important to note from an engineering perspective when testing occurs, but outside of that, it can occur at any time of the year.
Yeah, it can absolutely occur at any time of the year, and it would have the exact same results. We would love for it to occur right now, because of just coming straight off of the harvest and prior to planting. Again, we would love the opportunity to get in there, get it done, get it backfilled back to the condition, and then allow for planting for the next crop rotation to continue without any disruption to the current cycle. So if we could do that, that would be fantastic, and it would be less disruptive to the current landowner and leases that are currently taking place on those properties. So it can occur anytime. Now is a great time.
Thanks, Ryan. All right, I will continue to the next slide. So back to pile load testing. I'll just add a little bit more color to what I already covered on this one. So again, 26 test locations, piles or posts will be installed. So it'll driving posts with like a PD-10 or similar post driver equipment. It's about 16 feet long and 8 feet wide. So just to give you an idea of the size, takes generally anywhere from 3 to 5 minutes to drive a post in the ground. And then, like I mentioned before, for the purposes of the testing, they would remain in place for 72 hours. The posts would be painted and flagged just to make them as visible as possible. And then following the 72-hour period, an excavator would perform some load testing on the post in the ground, data collected, and then following that, the excavator will actually remove the post from the ground, and then any remaining void would be backfilled with native material or potentially sand if needed, and then topsoil replaced on top of that. Any questions on the pile load testing? All right. I will continue. So infiltration testing, it's essentially the infiltration of water, trying to get information based around that to give you a little more idea of what the purpose of this is for. In the examples shown in the photos, any vegetation for the test area, and you can see how small it is, would be stripped. Topsoil would be stripped and isolated. The test must occur on 12 inches below the native material, so that would be below topsoil. There's 2 concentric rings that would be used, one 6-inch, one 12-inch, that are placed on the native material and essentially filled with water and kind of timed as they infiltrate into the ground. 2 locations would be tested per day, total of 9 locations for this test. And then once that's completed, the 12 inches, or if it needs to go a little deeper based on how much organics there are on top, would be replaced. Topsoil would be replaced on top of that. So I alluded to this earlier in the presentation, but there's thermal resistivity testing that is mainly used in the electrical design for any buried utilities. Now, this isn't really a test in and of itself. It's collecting a soil sample in a 5-gallon bucket. So in areas where, say, a test pit is going to be tested, we would be able to remove a 5-gallon sample of the in situ material that would be tested, and it's not necessarily a test in and of itself unless there's any locations which are far and away from where a soil bore or a test pit would occur, in which case it would be hand dug by a shovel and placed and removed in a bucket. And that same comment would also apply to just the soil sampling that's going to be tested for any preconditioned contaminants or anything like that. And that is a condition of the CUP. All right, I'm going to continue on to the drain tile and gas line survey. So this is going to be performed by the same technology. It's called wave mode. It's a non-invasive subsurface survey technology. So the photo kind of shows what it would be. There's a line of small electrical devices that would be just with some metal, very narrow metal, like fence posts almost, smaller than that, placed in the ground. And data can be received from that. There's I think I have that in my notes. It was at the beginning of the slide, but 30 to 40 test locations in total. you wouldn't even be able to tell where this occurred, just because of the nature of the probes that would be placed and then removed from the ground, and the entire site would be able to be tested in 3 days. And again, that's to validate depth and location of buried drain tile and gas lines. All right. I believe I've covered everything there. Again, just to reiterate, as listed in the application, 13 would be the maximum crew size for all the testing. 7 employees would be part of the non-survey tests that'd be occurring, and then a maximum of 6 for the drain tile and gas line surveys that would be occurring.
Any other questions, commissioners, for the applicant?
Yeah, I got one. After all that testing is complete, how long does it take to massage the data and then use that to do engineering on the actual application?
Typically within 4 weeks or so. It can vary a little bit. It's usually constrained by the geotechnical engineers' kind of workload and whatnot. Could be expedited, but I would say typically 4 to 6 weeks is probably a pretty standard timeline to receive the data from that.
Okay, if there's no other questions, commissioners, we'll open this up for public comment. Thank you.
Thank you.
Is anyone here who would like to provide public comment on this item? Thanks, Jake.
Is this on? Yeah. Okay. Thank you. Good evening, commissioners. My name is Carol Schmidt, and I live at 2031 East 1250 Road in Grant Township. And my front door is approximately 100 feet from the edge of the proposed project. And I have supported this solar project since I first heard about it, and I still support it. And I want the commission to know that not everyone is opposed to it. I support it for environmental reasons. Energy use goes up every day, as we read today in the Kansas Reflector. It was reported that energy use in a 14 state, I guess, in the Kansas region will be almost doubled within 10 years. And we have a White House that denies the existence of climate change. So for me, the environmental situation is more dire now than it was even 10 months ago. Bill McKibben wrote in a New Yorker magazine piece this past July that converting some of the cornfields to solar panels makes enormous ecological sense. As more than 200 scientists at 31 colleges and universities across Iowa pointed out in 2023, a 1-acre solar farm produces as much energy as 100 acres of corn-based ethanol. So if we have 600 acres of solar panels, that would be equal to 60,000 acres of corn grown for ethanol. Ecologically, it's more beneficial to humans for the landowners to make money producing solar energy than ethanol energy at a ratio of 100 to 1. The benefit is 100 to 1, solar to corn. As a very close neighbor to this project, I have no objections to a TBU being granted for these samples, and I respectfully ask you to do so. Thank you.
Public comment?
My name is Emily Blodgett Panos, and I am the Grant Township Treasurer. I am here on behalf of the Grant Township to publicly state our opposition to the proposed TBUs for three main reasons.
Only can you get just a little closer to that microphone? Thank you.
Number one, the TBUs violate Judge McCabery's court order. We provide a copy of the judge's order in your written comments. The court ordered an injunction prohibiting any changes to the status quo of the property during the pendency of the litigation. The court's order prohibits the type of activity proposed in these TBUs. The planned excavation work and the use of excavation equipment for sampling constitute actions that would violate the injunction. Number two, this TBU relies on a CUP that is not operational. The TBU and the agenda report staff recommendations appear to reference and rely on Savion CUP-23-00312. County should not rely on a non-operational CUP for the terms of this TBU, as the CUP does not have the legal authority to hold any party accountable to its terms and conditions. Further, the applicant of the TBUs, Evergy Kansas Central, is not a party to the CUP. Therefore, even if it was operational, the CUP would not have legal authority over this applicant. Relying on a non-operational CUP puts the county and township at risk. It would leave the township no recourse for violations or damages done under the TBUs. Third, the application is deficient. To evaluate the impact on the township needs additional information. Specifically, the equipment list does not provide the number of passes by project vehicle and hauling equipment expected to travel on and operate on township roadways, nor have they provided actual sizes and weights of the equipment. There is no identified haul route. They have not provided the required traffic impact study required by the Section 12-306-4102 of the county's TBU requirements. In light of these concerns, Grant Township asks that the commissioners deny the TBUs. If the county approves the TBUs over Grant's objections, we request that the previous information be provided by the applicant and to adopt the specific conditions listed in our written comment. Thank you.
Any other public comment?
Good evening. I respectfully request that you deny these TBUs due to the ongoing litigation and
Can you
injunction.
introduce yourself real quick?
I'm sorry?
Can you just introduce yourself real quick?
Hi, I'm Nancy Thelman. I live at 1547 North 2000 Road. Voting for these TBUs will trigger further litigation as the injunction explicitly states plaintiffs have a reasonable probability of suffering irreparable future injury if the status quo of the real property is affected prior to the resolution of the current dispute. So tonight I ask you to maintain the status quo on the property until our litigation is resolved. And about this litigation journey, it is tough. But the more I learn, the more I am convinced that the lawsuit is necessary, even if it's uncomfortable. Serious mistakes were made, and what's worse, remarkable opportunities were lost. Some mistakes we already knew about before starting, like the county ignoring the Kansas Department of Fish and Wildlife's advice to move the project at least a mile away from the river, or the solar industry experts' advice to allow as much as a 15% slope to the solar site rather than just 5% to increase solar energy production and have the added benefit of opening up more thousands of acres for solar siting. But one thing we didn't know when we undertook this lawsuit is that the current solar site in Grant Township was not Evergy's first choice. Evergy originally wanted to build their solar plant on their own land near their coal fire plant, turning their brownfields to solar fields in a near perfect renewable energy development scenario. They sought advice from the county staff, hoping for a text amendment that would allow them an expedient site plan process. But Evergy's inquiry was met with a no, as staff said they were satisfied with the regulations as written. And that apparently was that. No doubt there's more to the story, and time and discovery will tell. But what a lost opportunity. How different things might be now had Evergy's original idea been met by the county with the kind of enthusiasm it deserved and put forward in a public process for deliberation rather than being privately and unilaterally scuttled. I suspect we all would have roared our support for Evergy in that original scenario, if only we'd been given the chance. The county's attorneys have not given us everything we're entitled to yet. This is just some of what we know so far, but we believe more will come out. For now, it's enough to share in hopes that you'll be dissuaded from taking action tonight in furtherance of this project with these TBUs. Please deny them until such time as the litigation is resolved. Thank you.
Let's call for public comment here. Sarah, is there anyone online? Okay, we'll close public comment, bring it back to the commission. Further questions, discussions, and/or motions?
A question for Carl. Hi. So this isn't the first TBU of this nature that we've looked at. What did you hear from Palmyra Township on any road use issues with the other TBU?
I don't believe we heard anything from Palmyra Township when those applications came forward
Or since?
or since.
Thanks.
I think this question is probably best for Sarah, but I'll just direct it at staff. We have it in our staff memo, but I think it might be helpful for a little bit of summary about how these TBUs came to us, and we asked for the court's guidance about how to move forward given the ongoing litigation and the temporary orders that are in place. So Sarah, if you want to redirect that to
have Terrell to do it.
Okay.
Thank you, Commissioner Reed. Yes, when the TBU came in and the county notified the township and other stakeholders about it, received, an initial objection and concern. I and the county agreed we would suspend processing of the TBU because we didn't want to run afoul of the restraining order that currently exists. I filed a motion with the court asking for clarification upon that order, as it could have various interpretations. We had a hearing on that. The judge decided that he felt it was premature and he didn't want to take away this body's political, your space to make your decisions on the TBU, because no decision had been made. He felt that was preemptive. So the advice provided from the judge was for the county to go back and complete its TBU process, and then basically come back. And so that's what we're here doing today. We're treating this just like we would any other TBU. You all are gonna make a decision, perhaps today, and then we will go back to the judge and ensure that what the county's decided it is or isn't going to do does not violate that order. Does that answer your question?
It does. Thank you. And I asked that question to make a point and distinguish what the different roles are that are being held. So us as commissioners having decision-making authority over certain processes that include land use, and there are different regulations for each of those processes. And so my interpretation and understanding about the court's guidance after the county raised the issue and sought that guidance in order to be, as you say, to not run afoul of the current court orders, that process is why we're here today. It's why we are considering the applications as they were presented. Everybody has the right to present an application. Staff process that as they would any other application, with the caveat of this, maybe a pit stop at the courthouse first for hearing about it and moved forward. And so I have full confidence that given the circumstances, that's a proper process. And there's a distinguishment between the role of the court and the role of the commission. And our decision today might very well be challenged or changed or further commented on within that court venue and the litigation. But we are moving forward on this, staff moved forward on this based on that guidance from the court. And I think it's important to distinguish roles and responsibilities and that there are differences in those. And it is, the county is not violating any court orders by moving forward with this. It will be the court's decision whether or not the activity, if approved, would be in violation of the court orders. And those are things for lawyers to argue in front of the judge later. So it just feels important to me to make that distinction and understand that why we're here is because we asked for guidance from the court about how do we move forward on this process, which is squarely in the purview of the county commission for land use, zoning and regulations and temporary business uses. And this is in step with the guidance. Now, I think that it's proper for us to be talking about the conditions that staff have imposed and determining whether or not those feel satisfactory, whether or not we wish to make any changes. In my opinion, that's squarely where our role lies tonight regarding this issue.
I have a question for Terrell. If we were to talk about adding a condition to our list of conditions that reflected that legal process, would you be able to suggest some language for what that would look like, that it's contingent upon the judge giving the go-ahead to move that forward? That seems like that's truly what we're talking about with this in terms of conditions. It'd be nice to also note that.
Sure. Do you want me to do that right now?
Might see if that's the direction that the commission as a whole wants to go. I just wanted to see if you
Well,
thought that was appropriate.
You could add a condition to say that we pass this contingent upon approval by district court in case number, and I can give that to you. Douglas County case number 2024 CV 153.
I wanted to read section E5 of the injunction. This order is binding upon defendant Board of County Commissioners to the extent that any vote, directive, or action of the BOCC purports to authorize physical entry onto or conduct activity upon the real property subject to the CUP under review. No such action upon the real property under such authority may occur until reviewed by the court. So it seems to me the court should rule first before we approve.
We tried that. He didn't agree.
Is that in writing?
Yes.
Why didn't you furnish that to us?
Well, it's not in writing. I have a transcript of the hearing that we went to. So I filed a motion for clarification because of that sentence and that provision. And the judge decided it was still in your court because you had not approved the TBU as presented and might depend on conditions here or conditions there. So you as a body could decide you're going to allow some of this testing, but not others of this testing. So he did not want to step on your feet here in this process. So the direction we got was for you all to decide what you approve, and then that would be conditioned upon subsequent approval by the court or agreement that it wouldn't violate the restraining order. Does that answer your question?
The other problem I have is the temporary business use permits include all of the testing by location, right? Not by type of test.
That's correct. The permits will be issued on a per section basis. So it's not specific to the type of testing that they're doing, just the locations that are proposed.
And in the past, we've had previous temporary business uses that have had multiple types of testing in
Correct.
one business use.
But those weren't covered by an injunction, probably.
Well, that's up to the judge.
Commissioner Dorsey, if I have some thoughts in response. Did you have another question though before? Did you have another question to ask of staff?
Oh, no.
I can appreciate your question and understand where it's coming from. I think, I think everybody can acknowledge that we're in a unique situation given all of the circumstances. It's a little bit of an order of an operation as far as I see it. And so county staff and council did the prudent thing by going and asking for the court's opinion and guidance. To your question about why those things aren't included in this packet, I mean, it's my opinion that all of those court documents are not relevant to this TBU. The application is to be processed by us as any other TBU would. Then the question goes back to the court based on our decision. If we approve it, then presumably there's a challenge about whether or not activity can occur based on the approval that the commission gave with the conditions included. And so then it becomes the court's purview to decide whether or not the injunction applies to it. And I would point out, since what you read in paragraph 5 is followed in the next paragraph by a section that says this injunction does not prohibit any incidental activity in furtherance of assessing the appropriateness of the CUP, such as, by example, engineering studies to be conducted on or upon the subject or surrounding property, so long as such action does not modify the real property in any meaningful way. Now, again, there's multiple interpretations and arguments to be had, but that doesn't occur in this venue. It occurs in the district court. Does that, that's just my response. I think that it's important to just be really clear about whether or not we would approve this activity based on all the conditions that staff have applied and all of the regulations and ways in which we look at every TBU that comes before us, no matter what the amount of size is or how many section properties are included.
I have a new topic if we're ready for one. So we have a request from Grant Township to change the language of testing hours to working hours. And I'm thinking what that's capturing, what that would capture if we were to go with that would be like loading and unloading of equipment, and everything would then occur within the hours that are suggested in the TBU as opposed to just the testing activity itself. What does the commission think about that?
I'd like Carl to respond to that.
My thoughts on that are that the TBU is for the testing activity, not for all of the other work that may be going on or driving to and from the site, loading and unloading. The purpose of the TBU is for the activities that may be most disruptive, like the pile driving that can generate noise. So my thought is that the other activity may not be quite as disruptive. Additionally, if the language were to be changed to limit all of that activity to normal working hours, that may extend the time frame that the applicant may need to do that activity. So staff isn't necessarily recommending any changes.
So I heard staff make an assumption there that it may impact the timeline. Would the applicant like to respond to that assumption? Would it impact your timeline? Come on up.
Mr. Chair, while the applicant's coming forward, we didn't give the applicant an opportunity to respond to public comment.
Thanks.
I guess so to address the question of whether or not the working hours versus, sorry, to address the question in short, it may impact the duration of the study. I guess ultimately it would really depend on what the different definitions of the working hours that would be allowable are. I think knowing that would make it quite simple to answer, but without knowing that, it may or may not.
So working hours would mean you couldn't be on site doing any work at all between those times. Is that right, Carl? If we change that to working hours, so that you'd only be on site between 8 and 5. Is that correct?
That's correct. Yes.
Okay, so 8 a.m. to 5 p.m. would be the restriction there. Okay. Again, I think it may extend slightly, but again, going back to some of the feedback I provided earlier, specifically that the testing would be able to occur within 15 days without any weather impacts, up to a maximum of 6 weeks. I think there's sufficient buffer in there, just my opinion. But again, I think it would be worth double checking on my end, but that's my initial position.
This is your chance to double check, to go talk to your team there, because we may change that condition. You said it was 15 days of time that you need to work, and then you have 6 weeks total is what I understood. So if you want to go double check, that'd be good.
And just to be clear, that would be no activity period outside of 8 a.m. to 5 p.m.
Yes, sir.
Okay. I would appreciate just one moment. Thank you.
And can we clarify, I believe the TBU is also allowing for a full year, correct? But then when they begin, they have that full period, correct?
The permit will be valid for a full
Full
year,
year.
but the testing activity needs to be done within a 6-week window
Correct.
within that 1 year.
Okay, all right. I just wanted to clarify that they have that full year, but then 6-week period once they begin.
Correct.
Okay, thank you.
Carl, I actually have another question for you. I was trying to think back to the last time we did a set of TBUs and what those hours were, but I didn't go cull through that. Can you tell me if you know from memory, or sort of what staff's consideration around the typical working hours or testing hours are?
This condition is the exact same language that was approved back in 2023.
In 2023, you're talking about the different, like the solar and MET testing tower TBUs.
It's the condition from the geotechnical testing in Palmyra
Thank you.
Township.
Yep, thank
Correct.
No concern on our end with the proposed change.
Okay, thank you. Do you want to take a few minutes and respond, and you don't have to any of the public comments that were provided?
I don't really have any response to provide to those comments at this time. I think I've covered everything sufficiently. Thank you.
Another question for Carl, kind of along this line of the 1-year timeframe. Because we don't know what the injunction does to this, and the timeline is normally I'd say the 1 year would be fully sufficient to deal with the weather and find a 6-week window that would work. But given that other consideration that we don't know and don't have any control over, should we be looking at something longer than 1 year? You had a recommendation in there, so I just want to see if you'd address that.
It's certainly within your purview to extend that time period for longer than a year. It's difficult to predict what the court is going to do. Should you approve the 1-year time period and the activity hasn't taken place yet, the applicant could come back and ask for renewal of those temporary business use permits.
I have a question for our attorney or Barbara Emerson or both. if either of you could comment on what would be the problem in delaying the testing until the lawsuit has run its course.
That's not a question for me, I don't think. Commissioner Dorsey, it's probably a question for the applicant, or Mr. Goff, if he would like to respond.
Hi, Damon Ray with Evergy, project manager. So the purpose of the testing is to facilitate the engineering design of the project, right? And so that takes time. We need to get materials ordered. The projects take a long time to plan before you can actually get on site and begin construction. So with the injunction in place, we can't start construction, but we want to be able to continue that planning process in the event that that is lifted and we are able to start construction. We want to be able to do that in a timely manner.
I can rephrase Commissioner Dorsey's question. Would we have a due process issue if we just kick the can down the road? I think is maybe what he's asking.
No, I mean, from the TBU perspective, I mean, I think as opposed to kicking it down the road, you probably deny it and then they can reapply later if that's what you want to do as a commission. Does that make sense?
Just a couple of thoughts here. In my reading, I appreciate the conversation I heard between Commissioner Dorsey and Commissioner Reed. And in reading through the injunction that was included in our packet and when we received it from staff from Terrell originally, I think there's a lot of ways to interpret that, right? We heard things on both sides. And so at that point, I figure it's really up for the court to make that decision and looked at this TBU as if it stands on its own without any consideration of the CUP, as if the CUP does not even exist, and allow the court to go in. To Commissioner Willie's point about, like, could we put something in there? I think that's any time we approve a TBU, the applicant or the public has the ability to take that to court to challenge it, right? And so what I want to make sure I do is not influence my decision by something that's outside of our current process of reviewing a temporary business use permit, because then we are setting a precedent going forward that we're getting one thing before the other. And I don't know what Judge McCabrio decided, but that's the way I looked at this is let's look at the impacts among the community. Let's think about what the conditions are and if they're appropriate, and just set aside the CUP and let the court kind of decide. Every time we make a decision, someone can file on that decision and we would need to respond. If we didn't, to the public comment that was made, if we didn't follow our own code, we could file again against the TBU, against that mistake on that could happen anytime we have a application. So I'm just personally, and I would encourage others to review it just as if it's a TBU, not attached to any CUP whatsoever. It is for a temporary business use permit this evening. I know it's all muddled up, but I think that to me is the best way forward.
I would also add that we have approved temporary business uses without a CUP in place. So this is a use that is completely allowable, even if there was not a CUP.
To Sarah's point, I just wanted to point out the temporary business uses for testing in Palmyra Township 2 years ago. No CUP has been brought forward for those yet.
I do have one question for the applicant about the equipment that will be coming in. I found it in the report, but if you could just reiterate it on what the number of trucks that will be coming in, the number of excavators that will be coming in. Do you have that information?
I do. So just to recap the equipment, there would be one drilling rig. There would be one pile driver. There would be one excavator, one skid steer, and then up anywhere between 3 to 5 light pickup trucks.
And would those be on site all 15 days of the time that you'd be doing the testing?
Not necessarily at the same time, no.
The equipment needs to be kept on private property is a condition. So would things like the excavator be brought there and left there over the 15 days, or is it going back and forth to the site?
It would be delivered to the first parcels that would be tested. Testing would be completed, and then removed from that area permanently, except in the situations. I guess it would be pile driving where there's a 72-hour wait period. But again, in that case, the post is installed in the ground with the pile driver piece of equipment. That equipment would be gone permanently, and then an excavator would be there to perform the testing and remove it. So for the most part, the equipment would be there once and then
So at
depart.
most, we'll have less than 10 vehicles traveling to that space over a period of 15 days. Is that correct?
That's correct.
Okay, thank you.
I had one question about the rig. Do you know the height of the rig? Approximately.
Approximately 15 feet.
Oh, okay. The reason I asked that is we had a golf course approval a month or two ago, and I learned from the applicant he had to get approval from the FAA for his light poles on the property because he was in the flight path for the Lawrence Airport. And I think this project is also within that sphere of influence, if you will.
It is.
Not that I think a plane's going to be flying 15 feet over the property, though.
There's another request in the Grant Township document about using about any new access points. We've already talked to the applicant that they'll use existing farm access points. I'd be happy to include that as a condition but I think that that's a condition that has already been kind of determined that could be met by the applicant.
If I may, Commissioners, the requirement for any new entrances to seek approval from Grant Township, that is completely separate from any temporary business use permit. That's a regulation already, so they would have to meet that regardless.
Okay, I thank you. And one final one. So in the staff report or in the conditions that the staff has provided, it asks for the applicant to let zoning and codes know 24 hours in advance before testing begins. Would there be any objection to having them also let Grant Township know at that same time? Or for zoning and codes to call them either way?
Once that email comes in, I'm happy to let anyone who wants to know. And I would promptly forward that email or send that out as soon as it comes in.
Okay, thanks.
Commissioners, I'm ready to move forward with a motion, but want to check if there's any further discussions or comments or any particular changes to conditions that.
Well, I still have an issue thinking we're violating a injunction by considering this at this point. Looking around the room, and I see 3 people that were in the court, 4 people that were in the courtroom that day. And I got the impression that the judge was telling us everything should halt until the case was settled. Now, at that time, the case was due to be tried in November, and now I hear it's pushed out to April or May. That's why I'm asking the questions about, can we wait?
I appreciate the questions being asked. My feeling is at this point, I don't think there's any loss to the county to, if we choose to approve tonight and the judge says you can't do that. I don't think there's any loss there really. I mean, it actually gives us more clarity on what we can and cannot do on the site, or what the applicant can and cannot do on the site, and what our actions are. I think if that happened, I would say like, I would be against approving anything else, but I'm looking for more clarity here. Pushing it down the road, it doesn't tell me anything new really. And so I think we made the move and to ask the judge for some more information on it, to make a decision on it. He deferred it back to us. I think it's our job to take action on it rather than defer the item.
So once we vote on it, Sarah, what would be the process? You would have to take this to the court for approval?
I apologize, Commissioner. I did not hear the beginning of that question.
If we approve this tonight, then what is our course of action? We have to take it to the court for concurrence or approval?
Yes, we would. He would have to, just like that order says, without further direction by this court or review by this court, right? We can't permit this activity. So I think that order requires any proposed or approved use of that property come before him, before any physical entry can occur, consistent with the TBU.
I would also just add, to put a point on something Terrell said earlier, also Commissioner Dorsey, that the judge's clarification and guidance in response to what should we do about this TBU application related to this project site is that because we hadn't made any, no decisions had been made yet, that it was improper for him to be able to make a judgment about whether or not that was a violation. So until and unless we make a decision, it's improper for the judge, for the court to be able to make a ruling on it, was his determination. So back to that order of operation, I think the only way to Commissioner Kelly's point, get clarity about how the court perceives this issue is for us to make a decision within our purview, which is limited and should be specific to our land use and regulations and the authority we have to make decisions on that. And then that will trigger the next step, which is the court can make decisions on our decisions on whether or not activity can move forward if approved. It's a sticky wicket.
I think outside of the injunction question, this falls very squarely within the kinds of things that this body has approved regularly and normally. I don't have any objections or difficulties with what's being proposed. I don't see any reason to deny it that would not be biased. And so the only thing that I would suggest a change in the conditions would be to change testing hours to working hours. And I think that's, I find that to be a reasonable change.
Commissioner Reed, were you going to make a motion?
Looking to see if there's consensus about making that change to the working hours. I'm seeing some affirmative head nods, so.
Agreed.
Okay, I think that's perfectly fine adjustment as well. And I'll scroll back up. This is Commissioner Reed. I move to approve temporary business use permits ZTBU 2025-2, 3, 4, 5, and 6 to allow utility scale solar related geotechnical site investigation, soil sampling, and underground surveying to be located in sections 1, 2, 11, and 12 of Township 12 South, Range 19 East of the 6th Principal Meridian, and sections 6 and 7 of Township 12 South, Range 20 East of the 6th Principal Meridian for a period from October 22nd, 2025 to October 22nd, 2026, with the conditions as recommended in the staff report, with one change from commissioners to quote, working hours instead of testing hours.
Second. Any further discussion, commissioners? All those in favor signify by saying aye.
Aye.
Opposed? Passes 5-0. Thank you very much, Carl. We now will move to an executive session. I have a motion for that executive session. I move that we recess to executive session for preliminary discussion of the acquisition of a real property and consultation with legal counsel about the potential acquisition. The justification is to preserve the confidentiality of the preliminary discussion and consultation with legal counsel, which would be deemed privileged in the attorney-client relationship. Attending the executive session will be County Administrator Sarah Plinsky, Deputy County Administrator Sean Peterson, and County Counselor John Bullock. No action will be taken during this executive session. We will return to our open meeting at,
I'd like 15 minutes, but I'd also like to add Chad Voigt to that executive session.
I'll allow it, and we'll add Director of Public Works Chad Bullock to the meeting.
Chad Voigt.
Oh, yeah, Chad Voigt. John Bullock's already on there. I was looking at Bullock. Yeah. No action will be taken. And do we need 30 minutes, do you
I
think?
think it's just 15.
15. Okay, let's
Unless
do
you
that.
want- yeah.
We will be back in session at 7:15. I need a second on that motion. We need to vote on it.
Second.
Moved and seconded. All those in favor say aye.
Aye.
Aye. Aye. All right, we have returned from executive session. Commissioners, are there any appointments
We
this
have
evening?
no act. Can you clarify?
Oh, yeah, we have returned from executive session and there is no action. Appointments, commissioners?
At long last, I have an appointment to recommend, and that is Chad DiCaprio, a local builder for the Board of Building Codes Appeals. And I would like to recommend him for that role.
Not had a chance to share that with the commission. So if you need more time and like to see that, I can share that to the commission and we can do that. It's up to the
met with
commission.
him and forwarded to Sarah just a very short bio. He's done a lot of restoration work. So the company name is DiCaprio Restoration, I believe, but has also done a little spec home building in Douglas County. He's worked in Lawrence and in other communities. And I think kind of having that view of working with a lot of different building inspectors is helpful. I find him to be a problem solver and a creative thinker. And I think that's what that role requires. That group doesn't meet very often. And when they do, it's at the request of a builder who is wanting that, so that you have to be either in one of the trades or a standalone builder to qualify for that role. But I would recommend him.
I don't have any problem going ahead with it. Commissioners, please weigh in if.
Either I appreciate your work on that and I'd be happy to second the recommendation.
Thank you.
I think that's a
Or
motion.
motion.
I move to appoint Chad DiCaprio to the Board of Building Codes Appeals.
Second.
Moved and seconded. Any further discussion? All those in favor, please say aye.
Aye.
Opposed? 5-0. Thank you, Mr. DiCaprio, for your service. Any other appointments? Okay, we'll move on to Commissioner Administrator Miscellaneous and start with Sarah's memo.
Thanks, commissioners. Want to point your attention to some things that we're going to keep this in my memo related to the Wakarusa Visioning Plan. There is a public open house on November 20th. I just want to, I think that'd be a great opportunity for commissioners, if you have time to come to that, to learn more about where we're at. And they're going to be on site for 2 days there, gathering a lot of input. So that'd be a great opportunity to hear more about that project. Also, Included in your packet is some information I received from Shannon Oury with the Lawrence Douglas County Housing Authority regarding the impact of utility costs on affordable housing and housing choice vouchers in Lawrence that I know was shared with the city of Lawrence. It might be interesting to commissioners as we have conversations around affordability and access to housing. And just a reminder that we do not meet next week. Sean and I and Jake will be at the International City County Managers Association, which is our professional association, and we'll be at that meeting. And then on the 5th, we will meet again and we will have a 4:00 work session. And commissioners, that's all I have.
What's the work session on?
It's on mobile integrated health with LDCFM and the court and coordination with vulnerable seniors. So Megan Poindexter will be here and we'll have folks from LDCFM and maybe more.
Any other miscellaneous items? Thank you, Sarah.
I had a question for Sarah. I went to the city commission meeting last night and the staff proposal from the city was adopted for firefighter salaries. You probably already knew that. Also, they passed purchasing 3 fire trucks, which come to a total of about $1.5 to $6 million. My question is, does that come out of our ambulance equipment reserve?
We do not pay for the fire trucks. We pay only for ambulances.
No, I'm sorry, these were for ambulances.
Oh, yes. Those are a part of our ambulance capital replacement schedule.
Okay.
And if they order them now, they're going to get them in 2 years. So it's a very complicated timing schedule as to when how we allocate the funds and then when they're actually received. But there is, that has been the plan and there is there's enough balance in there to cover that if for some reason they came in early, which I don't count on.
Commissioner, if I may, like to share just a few takeaways from the Ames and Des Moines trip with the intercity visit with the Chamber of Commerce, and I will kind of poke at Sean too to fill in some of the gaps. Really felt like it was a valuable experience. Both Ames and Des Moines had lessons for us, and kind of hearing those as a larger economic development community. So we had a county commissioner, a city commissioner, we had some city and county staff, and we have a large part of our business community that was present for those days of pretty intense presentations and site visits and such. A couple of takeaways from their town and gown, or how they're at Ames, how ISU, Iowa State University, interacts with the city of Ames. Ames being a smaller town somewhat than Lawrence, and ISU being a somewhat larger university. They really spend a lot of they showed us the face of really appreciating each other. And that actually comes out in terms of dollars also. That when I asked the question of their leadership in the city and the university, does their fire department pay anything towards their, does the university pay anything towards their fire medical response on campus? And the answer was yes, they pay a flat 25% of the city's fire med budget. Now they are a smaller community and a larger university, but that is a starting point for, I think, a larger conversation that I've poked at before in terms of what that obligation should be between KU and the city of Lawrence, or Lawrence Douglas County Fire Medical, including us. I didn't get to dig in further than that. It was one question, so I want to kind of reserve like all of the questions that come with that, because I didn't get a chance to ask them, including, do they pay for their own policing? Because KU has its own, police department. So is that an apples to apples comparison? Perhaps they're paying for one and not the other, and we do the opposite. There's just things to ask further questions about. Also, we toured their Iowa State University Innovation Park, which is about 20 years older than ours and booming. They have 22 buildings, 550 acres. 20 of those 22 buildings are on the tax rolls. So the ones that are not on the tax rolls are the ones that are most similar to what we have at the moment in terms of these are spaces that are jointly used by all the companies or are programming spaces or business development type spaces. But beyond that, those other 20 buildings are on the tax rolls. They started their presentation to us by saying, we are the largest payer of property tax in the city of Ames. And everybody's ears perked up. Because that's not the situation that we have here. And that got a little bit of reporting on also. Again, want to make sure that we're comparing apples to apples. Not all of their properties are on the tax rolls, and they're at a much further advanced stage than we are. But they felt, when I questioned some of their leadership, that this was kind of a nod to their development community, that they're not in competition, that they're offering something else that's a benefit, which we've talked about with our KU Innovation Park, that larger companies should and do want to co-locate with the KU startups that are kind of the original vision for KU Innovation Park. So I think we just have a lot to learn from that, and kind of I know we have through the KU Innovation Park board, we've asked for a vision for what the maturing of KU Innovation Park looks like in terms of return on investment and specifically around property tax. And that should come back to us probably at the next board meeting, kind of a draft of that, and hope to have something pretty close to submitting maybe in the spring, maybe around budget time, perhaps. So that's just a further conversation. I also would say that they have a lot of momentum there at the Iowa State Innovation Park. So they don't have to offer as many incentives to get companies to come, because they're really hooked into, of course, their agricultural community across the state of Iowa, because they're the agricultural school. So they specifically have inroads to manufacturing that happens in a lot of the small towns in Iowa. That's a method that won't work as well for KU as it would for an agricultural university. But anyway, there's some things to unpack with that. So before I move on to the others, that captures some of the Ames conversation around the town and gown.
Yeah, I think you've encapsulated it really well. The only other thing I would add is there's a lot of emphasis on just sort of a common brand, and that was amplified both in Ames and Des Moines, where again an umbrella group really took the reins and sort of leveraged sort of the collective will of those two communities. And I will say too that I think a lot of the attendees are still synthesizing a lot of what was discussed. This was even a little bit of a conversation point at the EDC meeting last week on sort of the heels of this trip. So I think there's more to come from these discussions that we had, and really look forward to how we can take those as learning lessons and apply them here in our community.
The big takeaway really was the regional focus that they have. So Ames works in coordination with a 3-county area. Des Moines works in collaboration with a 12-county area for economic development. They each have their chambers of commerce and their tourism groups and their arts groups. I mean, they have a lot of things. They have all the same pieces that we do, but they have kind of an overarching regional organization that manages the moving parts and really kind of keeps people on the same page. So at least what was presented was that unified brand, and everybody kind of finding where they fit within that and getting a lot done. They had a lot to show for themselves in both cities, Des Moines especially, which not as much overlap as we do with Ames, but they getting that momentum going for what economic development looks like. I think we had some lessons to be had there. One of the kind of interesting points in Des Moines is they have a massive farmers market. They shut down 12 city blocks for that every Saturday from spring until fall. And it also falls under this economic development umbrella, like intentionally, that and they offer makers spaces and stalls that are specific to entrepreneurs. So like here, there's 3 stalls just sponsored by this regional organization, so that an entrepreneur might be given like several weeks worth of kind of a pop-up space where they can decide whether they test out a product and see if it's ready for a retail space or not. So they really do merge some of our entrepreneurship initiatives through their farmers market. It's a different model of farmers market than we have, but that was interesting too, that they're just, we had a lot of voices in the crowd that I think we're picking up various pieces. And like Sean said, we're still processing, you know, some of those takeaways, but it was a worthwhile trip.
Thank you for attending, both of you. Appreciate the update. Any other miscellaneous items?
Yeah, I got one. I attended the KDOT local consult meeting yesterday in Kansas City, Kansas. It's held once every 2 years. They have kind of blue sky list of projects, and then people vote on them, and that's given some consideration in the priority of the project. Johnson County brought buses of people in, so their projects got the most votes. I think there were only 3 people in attendance from Douglas County. Myself, somebody from the city, and Rob Richardson was there. And our projects got 10 to 13 votes. But what I was surprised to see was they have a project down to extend K10 to 3 lanes from the county line to 1900 Road, which I'd never heard before. So that's on their list. You're probably talking 5 to 7 years away at the earliest, but I was shocked to hear that news.
So I just forgot to say, I went to the local consult in Topeka, and actually we had a pretty good showing from Douglas County folks. The city of Lawrence had a commissioner there, had some staff there. There were fire chiefs there, and then I was there. And so we divided, and some private citizens also, and divided among the groups, but really sold our projects pretty well. And the Douglas County projects, there are 4 of them, kind of rose to the top of that consult. So we had 2 shots at it. So thank you for being at the other one. And those projects were Highway 40, Highway 40, then the K10 from the Johnson County line to Eudora. And these aren't necessarily projects that are already funded and paid for. These are kind of like what's coming next down the line. And Highway 56 from 59 Highway West to Osage County. I'm also counting from Osage County to Overbrook as part of that pipeline. That also benefits Douglas County. So those projects all rose to the top, and I was glad to see that. There were also, you know, there's projects all across the region that are really important for funding and for dollars.
I do just want to quickly, there are additional consults that are going on. So they're sort of broken up by regions. The one in KCK is sort of the Kansas City metro region. The one that you attended is more of our kind of local region. There's also going to be a virtual consult, I think, in the next week or so. I can get that exact date and send that to you. I do want to acknowledge, Steve Kelly with EDC reached out to us, worked with the city of Eudora and Baldwin. Jessica Mortinger with the MPO has been part of these. So there's a lot of storming before the norming as far as the projects and how they get into the pipeline. But I do just want to appreciate KDOT's efforts in terms of reaching out to the local governments, local citizens across the state to really amplify the important projects that we're looking forward to.
The one good news is I learned one of the planning engineers lives in Eudora.
I know Commissioner Anderson was there last night as well, and we both attended the CHIP update, and Sarah was there. Thank you for being there. I just want to commend our staff members. Bob and Sarah are 2 of the conveners there. Not Sarah, Jill are 2 of the conveners of that. There is some very good news to share, sort of a year into this CHIP and where we are now. And I know some of it has been shared here, but it was a really nice event. I really wish it had been better attended. Many of the people who were there are the conveners, which is great to have them there. But I think when we're talking a community health plan, I'd like to see more people engaged. So I don't fault anybody who organized it. Jonathan and his team are doing a great job. But it's always interesting to me which things in the community get a lot of attention, and sometimes the work that's not getting the attention is maybe some of the most important work. But congrats to the staff. They did a super job at that event. Anything else, commissioners? All right. With that, we are adjourned.